Chapter 27. Cheating and False Pretences. Section 490. Cheating at Common Law. The common law crime of cheat consists in fraudulently obtaining a pecuniary interest in another's property. By means of some false symbol or token of such a nature that common prudence cannot guard against it. It is essential that the means of perpetuating the fraud be a false symbol or token, such as a false measure, a false weight, a false stamp, etc., or a conspiracy to cheat. A false statement is not sufficient. Where the defendant delivered 16 gallons of beer to the prosecutor, falsely representing the quantity to be 18 gallons, and for which he received pay, the conviction was quashed because the fraud was not perpetrated by means of a false measure. In the case cited, Lord Mansfield observed, the offence that is indictable must be such a one as affects the public, as if a man uses false weights and measures, and sells by them to all or to many of his customers, or uses them in the general course of his dealing. So, if a man defrauds another, under false tokens, for these are deceptions that common care and prudence are not sufficient to guard against. So, if there be a conspiracy to cheat, for ordinary care and caution is no guard against this. Those cases are much more than mere private injuries, they are public offences. But here, it is a mere private imposition or deception. No false weights or measures are used, no false tokens given, no conspiracy, only an imposition upon the person he was dealing with, in delivering him a less quantity instead of a greater, which the other carelessly accepted. It is only a non-performance of his contract, for which non-performance he may bring his action. The selling an unsound horse, as in for a sound one, is not indictable. The buyer should be more upon his guard. In the same case Justice Wilmot held, the true distinction that ought to be attended to in all cases of this kind, and which will solve them all, is this, that in such impositions or deceits, where common prudence may guard persons against the suffering from them, the offence is not indictable, but the party is left to his civil remedy for the redress of the injury that has been done him. But where false weights and measures are used, or false tokens produced, or such methods taken to cheat and deceive, as people cannot, by any ordinary care or prudence be guarded against, then it is an offence indictable. Again, where the defendant was convicted of knowingly exposing for sale and selling a gold chain, under the sterling alloy, as and for gold of the true standard weight, a motion in arrest of judgment was sustained. In this case Lord Mansfield, C.J., said, the question is, whether the exposing route gold to sale under the standard is indictable at common law. It is certainly an imposition, but I incline to think it is one of those frauds only which a man's own common prudence ought to be sufficient to guard him against, and which, therefore, is not indictable, but the party injured is left to his civil remedy. Notwithstanding the earlier rule that a false statement alone is not sufficient, in some recent cases in this country one has been convicted of false pretense who sold as sound a horse which he knew to be unsound. Wharton states broadly that this crime can be committed by means of deceitful and illegal practices and devices, and this view is supported by Stephen, but Bishop S. view is that the devices used must be symbols and tokens. Again, the former states that the device used must be such as might deceive the public generally, while the latter states that this is not essential. By an Old English statute, the token used may be a privy one, and this statute is part of our common law. Section 491. What constitutes a false token? A false token, at common law, is anything which has the semblance of public authority, as false weights, measures, seals and marks of produce and manufacture, false dice, marked cards, and things of a similar kind. False and deceptive. A privy token has been defined as something false and purporting to come from one not the bearer, and having in itself some private mark or sign, calculated to induce the belief that it is real, and thus to cause the person to whom it is delivered to part with his money or goods to the bearer or person delivering it. In the case cited, the defendant was convicted of cheating by passing to the prosecutors a promissory note for $10, pretending that it was of that value, and that the makers were in law liable to pay, and would pay the same, when she in fact knew that they were not liable to pay, and would not pay the same. The court held that the offence was a mere civil injury and a motion in arrest of judgment was granted. Similarly, where the defendant was convicted of cheating by passing to another a fictitious order on a banker, knowing that he had no authority to draw it, by means of which he got possession of certain lottery tickets, the judgment was arrested. Again, where the defendant was convicted of cheating at common law, and the proof showed that he obtained a letter from the judgment creditor to the magistrate who rendered the judgment against defendant, to discharge it on receipt of costs, and that he obtained the letter owing to his statement that he had come to settle, and would pay $10 down and give his note for the balance, but that, on receiving the letter went away without giving either the $10 or the note, the court arrested the judgment, and in doing so, said, "We search in vain for the false token." There was not even the production of either note or money, and common prudence would have dictated the withholding of the receipt until the money was paid and the note drawn. To support this indictment would be to overset established principles. On the other hand, where the defendant, a baker employed by the United States Army, was indicted for a cheat, in baking 219 barrels of bread, and marking them as weighing 88 pounds each, whereas they severally weighed only 68 pounds, the indictment was sustained, the court saying, that this was clearly an injury to the public, and the fraud the more easily perpetrated, since it was the custom to take the barrels of bread at the marked weight, without weighing them again. The public, indeed, could not by common prudence prevent the fraud, as the defendant himself was the officer of the public pro hac vice. Under some statutes there must be more than mere false words to constitute the offence. The delivery of short weight for full price is held false pretense. Section 492. Cheating by false pretenses. Obtaining another's property by means of false and fraudulent representations is not a crime at common law. To overcome this defect of the common law, statutes have been passed both in England and in this country. The original English statute provides as follows: whereas divers evil-disposed persons, to support their profligate way of life, have by various subtle stratagems, threats and devices, fraudulently obtained divers sums of money, goods, wares, and merchandises, to the great injury of industrious families, and to the manifest prejudice of trade and credit, therefore for the punishing all such offenders, be it enacted by the King's most excellent Majesty, by and with the advice and consent of the Lords Spiritual and Temporal and Commons in this present Parliament assembled, and by the authority of the same, that from and after the 29th day of September, 1757, all persons who knowingly and designedly, by false pretense or pretences, shall obtain from any person or persons, money, goods, wares or merchandises, with intent to cheat or defraud any person or persons of the same, or shall knowingly send or deliver any letter or writing, with or without a name or names subscribed thereto, or signed with a fictitious name or names, letter or letters, threatening to accuse any person of any crime punishable by law with death, transportation, pillory, or any other infamous punishment, with a view or intent to extort or gain money, goods, wares or merchandises from the person or persons so threatened to be accused, shall be deemed offenders against law and the public peace, and the court before whom such offender or offenders shall be tried, shall, in case he, she or they shall be convicted of any of the said offences, order such offender or offenders to be fined and imprisoned, or to be put in the pillory, or publicly whipped, or to be transported, as soon as conveniently may be, according to the laws made for the transportation of felons, to some of His Majesty's colonies or plantations in America, for the term of 7 years, as the court in which any such offender or offenders shall be convicted shall think fit and order. Somewhat similar statutes have been enacted in the various states of this country. Section 493. Definition and Essentials. The crime of false pretenses is the act of knowingly and designedly obtaining the property of another by means of a false and fraudulent representation. The representation must relate to a past or existing fact, and not be a mere promise or expression of opinion. It must be knowingly false and be made with intent to obtain another's property fraudulently. It must be calculated to deceive and defraud, and actually induce another to part with his property by reason of the deceit and fraud. Section 494. The representation must relate to a past or existing fact. the representation must be more than a mere promise to perform some future act. It must relate to a past or existing fact. Thus where proof showed that the defendant procured the prosecutor's endorsement of the defendant's promissory note by falsely and fraudulently representing to the prosecutor that he would use the note so endorsed to take up and cancel another note of the same amount then about to mature, and upon which the prosecutor was liable as endorser, that instead of so doing he procured it to be discounted and used a portion of the proceeds for other purposes. On appeal, the order arresting the judgment of conviction for cheating by means of false pretenses was affirmed, for the reason that, a false pretense to be within the statute, must be the assertion of an existing fact, not a promise to perform some act in the future. A statement that a horse is sound made knowingly that he is not, may constitute the basis of an indictment for false pretenses. In another case, where the defendant was convicted of this crime, the proof showed that he falsely and fraudulently promised the prosecutor that he would employ him and pay him $50 a month for his services, that the prosecutor, believing the representation and relying on the promise, deposited $100 as security for the faithful performance of the contract. On appeal, the conviction was reversed on the ground that the transaction was simply a private cheat, that in morals, the imposition was gross and detestable. But, in logic and law, the offense consisted in making a false and delusive promise, with no intention of performing it, which is not indictable. Again, where the defendant went to prosecutor's stall to purchase some meat, the prosecutor informed him that he would not trust him. The defendant promised that he would pay for the meat when delivered and by the subterfuge got the meat, intending all the time not to pay for it. The judges held the conviction wrong, that the false pretense was merely a promise for future conduct, and common prudence and caution would have prevented any injury resulting from its breach. Where the false pretense consists of a statement of fact and promise combined, it is sufficient to make the offense indictable. Thus, where the defendant was convicted of obtaining £8 from the prosecutrix by falsely and fraudulently representing to her that he was a single man, and that he would use their money in furnishing a house for them to reside in, and that he would then marry her, the conviction was affirmed. False statements as to the power to communicate with spirits may constitute false pretenses. Section 495. Representation must be more than an expression of opinion. Where the false representation is a mere expression of opinion as to value, quality, etc., or a mere puffing of one's property, it is not an indictable false pretense. Thus, where the defendant was convicted of obtaining money by false pretenses, and the proof showed that he obtained a loan secured by mortgage on his wife's land by stating to the lender that the lots were near the city limits, on a street leading directly to the business district, nicely located, and would sell any day for $1,200 to $1,500 cash, the conviction was set aside, because the representation that the lots were nicely located, and would sell any day for $1,200 to $1,500 cash, was a mere expression of opinion. On the other hand, where the false representation is something more than a mere expression of opinion, amounting substantially to a statement of fact, the false pretense is indictable. Where the defendant was convicted of false pretenses, and the proof showed that he defrauded the prosecuting witness by inducing him to purchase a horse which had long been afflicted with swinny, by falsely stating to him that the horse's lameness was the result of recent shoeing, and was merely temporary, a refusal by the trial court to instruct the jury that, if the purchaser could perceive the lameness, the principle of caveat emptor was applicable and the defendant was not guilty, was held proper and the conviction was affirmed. Again, where the defendant was convicted of this crime, and the proof showed that he fraudulently induced the prosecuting witness to purchase a diseased horse that was almost worthless by stating that the horse in question was a real nice driving horse, was a good one and very fast, that it belonged to a lady, but that it had always worked for him, all of which statements were false, the conviction was sustained. It is sometimes difficult to discriminate between fact and mere opinion. Thus, where the defendant was convicted of obtaining money by false and fraudulently representing to a pawnbroker that certain spoons he pawned were plated equal to Elkington SA, and on the best foundation material, the conviction was set aside by a divided court. the majority reasoning that it was not the intention of the legislature to make it an indictable offense for the seller to exaggerate the quality of that which he was selling, any more than it would be an indictable offense for the purchaser, during the bargain, to depreciate the quality of the goods and to say that they were not equal to that which they really were, while the minority held that there was a false pretense, namely, that the goods had as much silver on them as Elkington's and as to the foundation, that these were matters of fact, not opinion, as to matters of quantity and quality. The dissenting opinion in this case, it is submitted, is, upon principle, correct. Moreover, statements relative to quality and value can be statements of fact, as well as statements relative to quantity and weight, and such statements, knowingly false, and which fraudulently induce another to part with his property, may be sufficient to make the offense criminal. Section 496. The representation must be knowingly false and made with fraudulent intent. The representation must be actually false and made with intent to obtain another's property fraudulently. To obtain goods with the intent to defraud is not enough. It must be accomplished by a pretense which is false, if the party who makes it believes it to be false, when as a matter of fact it is true. The act is not indictable. So, where the defendant was convicted of obtaining goods by falsely and fraudulently representing that a certain crop to be raised was not under mortgage, and the proof showed that a mortgage, which the indictment alleged covered the crop in question, did not specify the land on which it was to be raised, the conviction, on appeal, was reversed, because the trial court erred in admitting parole evidence to supply the omission, and therefore there was no false representation. The representation must also be known to be false. To give it a criminal character there must be scienter. Thus, where the defendant was convicted of procuring money from a bank by false pretenses and with intent to defraud, and the proof showed that he obtained the money by presenting 2 checks which were overdrafts, on appeal the verdict was set aside and a new trial granted on the ground that the proof did not establish the element of scienter. If the checks in question had been passed to a third person, it could not be said that the defendant knew that they would not be paid. On the contrary, he had an open account with the bank, and although he knew there was nothing due to him, yet he might suppose that they would be paid. And the fact that he presented them himself, shows that he did not know that they would be refused. They were mere requests to pay to him the amount named in them, couched in the appropriate and only language known there, and addressed to the person, whose peculiar province and duty it was to know whether they ought to be paid or not. He complied with the requests, and charged the sums paid to the defendant, and thus created a contract between the parties. Upon this contract the bank must rely for redress. It is to be observed, however, that the drawing and passing a check on a banker with whom the drawer has no account, and which he knows will not be paid, is a false pretense within the statute. This doctrine is approved by all the text writers. Moreover, the representation must be made with fraudulent intent. The defendant was convicted of obtaining a pair of shoes by means of false pretenses, and the proof showed that he and his family received relief from the parish, that the overseers of the parish ordered him to go to work and help maintain his family, that he replied that he could not because he had no shoes, that the overseer thereupon supplied him with a pair of shoes, that at the time he had, in fact, 2 pairs of new shoes which he had previously received from the parish. On the case reserved, the conviction was set aside on the ground that the representation made by the defendant was rather a false excuse for not working than a false pretense to obtain goods. Again, where the defendant was convicted of obtaining money by false pretenses, and the proof showed that he intended to buy a lot, that he told that he was the owner of it and sold it to him for $200, that he then made a contract with the true owner for the purchase of it, paying part of the purchase price, that he went into bankruptcy and never paid the full price of the lot nor acquired title to it, but that after his discharge in bankruptcy from a liability on his land contract he revived this liability by making a new promise to pay it. The conviction, on appeal, was reversed on the ground that when he made the false representation to gave him the deed to the lot and obtained the $200, he did not entertain a fraudulent intent. So where a congregation invited one not a minister to preach and paid him for his services, he was not guilty of false pretenses in obtaining the money, when, Beyond representing himself a minister, he took no steps to obtain employment. The fact that the other party to the transaction is also guilty of false pretenses is no defense. Where the defendants were convicted of obtaining watches by false pretenses, and the proof showed that in the trade the prosecuting witness also overstated the value of his watches, the conviction, on appeal, was affirmed, the court holding that, if the other party has also subjected himself to a prosecution for a like offense, he also may be punished. This would be much better than that both should escape punishment because each deserved it equally. Some courts have erroneously held the contrary. Again, where the defendant was convicted of procuring by false pretenses another's endorsement upon a promissory note and the proof showed that the party who endorsed the note knew that his endorsement was to be used dishonestly, this fact was held to be no defense. The procuring of the payment of a just debt, already due by false pretenses, is not indictable. Section 497. The representation must be calculated to deceive and defraud and actually do so. Where the representation is plainly irrational or absurd, and the victim is defrauded owing to his own gross carelessness, the crime of false pretenses is not committed. Thus, where the defendant was convicted of false pretenses, and the proof showed that he obtained money by representing to his victim that he was a witch doctor, and could kill and destroy witches, that the person to whom the representations were made was the victim of witches, that unless this person employed him to destroy the witches they would kill him and his family, the conviction, on appeal, was set aside on the ground that the representations were mere expressions of opinion and not calculated to deceive a man of ordinary understanding. On the other hand, where the defendant was indicted for obtaining money under false pretenses, and the indictment alleged that he obtained $200 by falsely pretending to sell and deliver $2,000 in a box for $200 well knowing that the box contained only $1, a writ of certiorari to review a refusal of the trial court to quash the indictment was dismissed, the court saying, the third alleged infirmity in the indictment is that the false pretense charged is such that a person of ordinary prudence and caution would not be deceived by it. To this, it is a sufficient answer that it is of common knowledge that many persons have been deluded by a like artifice. Laws are made to protect weak-minded and credulous, as well as sagacious, persons. The wise and wary can protect themselves. As a rule, gross carelessness is a defense, but not mere credulity. Whether the representation is calculated to deceive or not is to be determined by giving consideration to the surrounding circumstances and the intelligence of the victim. And it has been held that even where the proof shows that the exercise of ordinary care on the part of the defrauded party would have prevented him from being misled, it is still for the jury to determine whether he relied on the false representation and was thereby defrauded. However, it is not necessary that the deceived party should ultimately suffer loss. Section 498. Nature of the property obtained. As a rule, the property obtained by means of the false pretenses must be such as to be capable of being stolen. Hence it cannot be land. It is to be observed, however, that there are exceptions to this rule. Thus, the statutes of Wisconsin provide that obtaining by false pretenses a signature to a written instrument, the false making whereof would be punishable as forgery, is indictable. Under these statutes, however, which make money, goods, wares, merchandise or other property the subject of false pretenses, it has been held that they do not include boarding and lodging. And, at common law, obtaining dogs by means of false pretenses is not a crime. Real property does not fall within the statute. Section 499. Property versus mere possession. In the crime of larceny the thief acquires only possession of the property. In the crime of false pretenses, however, the wrongdoer acquires, under most of the statutes, the property itself. It has been held, however, that it is not essential that title to the property pass. It has been held that where the wrongdoer obtains the goods by falsely and fraudulently representing that he was sent for them by a customer for whom they are intended, he is guilty of the crime of false pretenses, notwithstanding the fact that the title to the goods does not pass. Section 500. The false pretenses can be by acts as well as words. It has been held that the false pretenses must be either oral or written. This view, however, is erroneous. Words are merely signs of ideas. If the ideas are conveyed, the channel of communication, or the garb in which they are clothed, is immaterial. In this case the distinctive dress worn by the wrongdoer constituted, in part, the false pretenses. He was convicted of obtaining a pair of bootstraps of one by falsely representing that he was a student at Oxford University and a commoner of Magdalen College. The conviction was sustained upon proof that at the time he obtained the goods he wore a commoner's cap and gown, and falsely stated that he belonged to Magdalen College. So convictions of false pretense have been sustained where there was a mere drawing of a cheque on a bank where the drawer had no funds, though there was no representation that the cheque was good, except that implied from offering it. But one who merely goes in an eating house and orders food with no money to pay for it is not guilty of false pretense. It also has been held that the false pretense must be the sole inducement that causes the party to part with his property. This view is contrary to the weight of authority. The false pretense must play a material part, however, in defrauding the party, and must have such an influence upon the owner, that, had it not been for the false pretenses, he would not have parted with his property. Section 501. The statutes applicable to donations for charitable purposes. It has been held that the statutes relating to false pretenses are restricted in their application to commercial transactions. This view, however, is wrong on principle and contrary to the great weight of authority. They are also applicable where the wrongdoer by false and fraudulent representations induces another to donate money for charitable purposes. Section 502. Confidence games. In some states there are statutes which make it a crime to obtain money or property by any means, instrument or device commonly called confidence games. This is in fact a species of false pretense. Confidence games have been defined as a swindling operation in which advantage is taken of the confidence reposed by the victim in the swindler. It seems that the employment of false tokens is unnecessary to conviction for this crime, and that it is sufficient to prove the obtaining of property by false verbal representations. It is immaterial that the scheme by which the accused took advantage of the confidence of the one swindled, was in form a business transaction,